and we're going to talk about conducting effective workplace investigations. Joining us today is Andria Ryan. Andria is a partner in Fisher Phillips. She works out of the Atlanta office, but she is all over certainly the US, and I think they've actually started, and she can clear this up, but I think they've actually started to do some international work as well. But Andria is the co-chair of the Hospitality Industry Practice Group at F&P, and she's a member of the Workplace Investigations Practice Group. She's also deputy counsel of the firm. She's been honored by numerous hospitality organizations, including receiving the Anthony G. Marshall Hospitality Lawyer Award. And we're just always thrilled to have her with us. Please welcome Andria Ryan.
Thank you, Stephen. I appreciate it very much. I could probably talk for 30 minutes about alcohol and cannabis as it relates to employment. But we are going to pivot and talk about conducting effective workplace investigations. One thing I'm going to warn you about is this is a dense PowerPoint, and I'm usually a little bit less wordy, but there's a lot of information out there. I'm hoping it will be helpful to you if you are either conducting investigations or managing investigations as you move forward and plan for some of those. So my first slide here is I want you to stand back and remember why we're investigating. We know as HR professionals, as legal professionals, when we get a complaint or concern, our gut reaction, our knee-jerk reaction is we need to investigate this. But if we remember the why, I think it can often help guide our investigation. Obviously, looking into concerns, and usually in the workplace, it's a discrimination, harassment concern, or complaint of perhaps violence. It's going to foster your diversity and inclusion efforts. I think every company needs to create and maintain and live a speak up culture so that we tell employees, when you see something, say something, and do so without fear of retaliation. We obviously want to prevent and deter improper, unsafe conduct. As you all know, the legal standard in harassment cases for some types of harassment is you can't prevent it all, but once you learn about it, knew or should have known about it, we have a duty and an obligation to prevent it from happening again. So we show our commitment to our code of conduct, our ethics, our policies and practices, and then limiting legal exposure. That's a big why. The next slide will show you just a little reminder of, at least in the employment side of the process, the timeline, and the potential expense for mediation. Now, this is not a quote for any of you. It's really just to give you an idea that we're talking about $75,000 to $450,000 plus in legal expenses alone, just to get through the initial filing of a discrimination case through trial and appeal. And that's probably a little conservative. So that is a big why. I think if next slide, please, Mo. I think investigations are an art form. Some people are good at them and some people are not as good. I don't think anybody's bad. Well, I guess somebody could be bad at them, but I think people can improve their skills. But someone who's going to take on a workplace investigation needs to keep in mind that every investigation is different. It's going to require judgment under the circumstances of the case, the people involved, the dynamics of the department, the seriousness of the complaint. It is often difficult to know who is telling the truth, and I'll talk about a slide later where once we get to the he said, she said part of it, a lot of us throw up our hands, and we shouldn't. So we can get to the truth, or we can get close to the truth often. Investigations and decisions made one day may be attacked in another. My previous slide talked about litigation. Your investigation in a workplace situation is likely to be challenged in litigation, so it needs to be done well and with care. And good news is that we need to take it seriously, act fairly and impartially, try to find out what happened, and then take proper steps to address it and prevent future conduct, as I mentioned, and then confirm no retaliation. I've always told folks when I train managers and supervisors that retaliation, I think, is easy to do. It's not proper, but it's easy because it's natural. it's natural to not want to work with someone that's been complaining. Perhaps you have a persistent complainer, or you have someone who's made a career-threatening complaint against you. It's human nature to not want to be kind or to work with that person. It's something somebody in leadership roles have to really try to overcome. So let's start with, you've received the complaint, and I want you initially to consider some sort of interim action. With a very serious allegation, consider whether the accused should be placed on some sort of leave of absence pending the completion of the investigation. I find that often when you remove the alleged wrongdoer, people may be more open to talk without fear of being seen, being called to an office, or being asked, face to face what they've said or what they might say. So it may be easier. Threats of violence, harassment, violation of the drug and alcohol policy, all opportunities for perhaps removing the accused wrongdoer. Whether you call it administrative leave of absence, a suspension pending investigation, either one, whatever works for you internally, but it generally should be paid. I think there are some circumstances when not, but the leave of absence should generally be paid, which will also motivate us to timely complete the investigation, because we've got someone sitting outside receiving their full pay. So maybe a temporary relocation of an alleged wrongdoer is an alternative as well. You should never involuntarily place a complainant on the leave of absence. It looks bad. It could deter others from complaining. It looks like retaliation. And so unless they want to be removed, they voluntarily would like to be removed, then I always recommend against that. So consider that interim action before you start your investigation, and then ready. Let's go. Step one, plan the process. Experienced investigators often say, okay, I'm ready. I'm going to jump. I'm going to go. And I think it's important that we plan the process and we put it in writing. Remember, we potentially are defending this case someday, our investigation of this case. So the first question is, who's going to conduct this investigation? It's always the first question. I'm a big fan of either human resources, an outside third party, a trained investigator, or counsel. The last three on my slide here present some concerns. A manager may have a predetermined opinion about those involved. I mean, remember, they're a day-to-day, they see them day to day. Some of them are good employees, some of them not so great employees. They all have their pluses and minuses. An executive level employee may be looking at things from an operational perspective versus balancing that risk management perspective that we know comes in workplace investigations. A manager who has future decision-making responsibilities over the complaining party, or the accused for that matter, with regard to discipline, termination, performance reviews, advancement in the company. So I lean towards one of the first two. If you've got that resource available, that's the direction I would lean in. The next step is plan the process and have a written plan, and plan to deviate from your plan. Be prepared to deviate from your plan. What will be investigated? What's the complaint? What are the key issues? And an outline of the investigation that's be collected, an initial list of who will be interviewed, and where the interviews will be conducted. This sometimes can be challenging. I have myself conducted witness interviews in hotel lobbies and KFCs and Starbucks and alternative office locations. If your company has alternative offices where the folks involved don't work, somebody's office in a remote location may be helpful. So plan that part of the process very, very early on. How will the investigation be conducted? Important question here. The fact gatherer, the investigator, are they going to make recommendations, or are they going to provide facts and someone else is going to make a recommendation or a decision? We need to discuss in what order the witnesses will be interviewed. I have seen a couple of slides coming up. The complaining party is always the first one because we need the details of the complaint, obviously. But there is an art sometimes to who's interviewed when. When do you approach the party that's the accused? When do you interview witnesses that may provide information to other witnesses or may taint future witness statements? So there may be some thought to that about the how and when a witness will be interviewed. How are you going to approach witnesses? What are we going to say? Who's going to approach them? Their supervisor, their manager, HR, who's going to deliver your part of the investigation we're conducting, and we're requesting your cooperation. What about an uncooperative witness? When I'm conducting an investigation, I always ask, who do we anticipate will be uncooperative? Who has recently been in trouble? Who's involved? Who's related to the accuser or the accused? Who's had a previous relationship, friendship, or romantic? And how are we going to handle that? So anticipating that can give you some comfort before you actually start the interview. So next, I'm going to collect relevant documentation. Policies, personnel files are a wealth of information. Performance reviews, prior complaints, text messages, anything available to me, and I'm going to review those prior to the interviews. I think there's information in there that when I'm conducting an interview and someone is not being truthful with me, I've already got that information and I can take that into consideration. I may not confront them with that at the moment, but now I know I've got a concern about some credibility issues. I was interviewing a witness recently, and I knew from other information that the information he had received on a situation was from his sister-in-law, who happened to also be a guest at the restaurant. And when he talked to me about it, he said, this guest came and made a complaint. I said, okay, it's just a random guest? Yes, a random guest who happened to be a sister-in-law. And so I knew to be a little bit hesitant about the information that I was getting and to probe in a different way, because I could tell that my witness was not giving me the full picture because of information I had prior to the interview. So let's talk about interviewing the reporting party. I think there's obviously remain objective. We're going to remain objective throughout this investigation, but this is the individual you set the tone for immediately. If this employee, the reporting employee, feels that you're tainted right off the bat, the entire investigation will be tainted. So you need to remain objective and convince the reporting party that you are objective. I like written statements, but I don't like written statements that are completely controlled by the writer, the employee, for example, because they put in there what they want. So if you accept a written statement or a written complaint, tell the reporting party that you may ask them to supplement it based upon information you received during the investigation and during your interview with them. Because remember, reporting party tells us exactly what they want us to hear and not much more. And so when we gather more information, it's important to get that into a signed statement. So maybe you have a written statement from them and a supplement that is prepared by you that they sign, or prepared by them once you interview them. I think it's important to find out if this is an isolated incident or a part of a series of events. One of the questions I always ask reporting parties, especially in harassment complaints, for example, or discrimination complaints, did you tell anyone else about this at the time that it happened? I operate under the theory that it takes people a while to decide to complain formally. And perhaps things have been going on for a while, or they've had a single incident that they've been sitting on, thinking about and stewing over. And they may have told friends or coworkers because they shared their concerns. Should I complain? Should I not complain? So I always want to know if there's somebody that you told at the time that the incident occurred. And when I interview that witness, I want to make sure that what they were told at the time is similar to what we're being told today. And it's not been exaggerated or deflated, for that matter. Get specifics. I'll go back one real quick. Get specifics. Do not accept it was offensive. Ask the employee, the reporting party, what did the individual say? I'm not embarrassed by bad words. I've heard a lot. I'm in HR. I can handle this. Tell me exactly what was said, when it was said, if you were touched, where you were touched. You have to set aside your potential embarrassment about those kinds of issues and questions, and put the reporting party at ease that it's okay to tell you the story. And then, of course, identify additional witnesses, including the ones I just mentioned before. All right, Mo. I wanted to pause here a moment on confidentiality. Under the current National Labor Relations Board's position on confidentiality of investigations, we have to be cautious about telling employees and reporting parties that they must keep what was said to you or this investigation confidential. Employees are permitted under the National Labor Relations Act to talk to each other about concerns they have in the workforce, their working conditions. And that may be, and a complaint they have about how they're being treated at work is certainly one of the areas that they complain about. So I urge you to be cautious about requesting confidentiality. I think concentrating on protecting the integrity of the investigation is a path you can go down, but not to keep it quiet so that other people don't learn about it. So, maybe encourage confidentiality so that other people's statements aren't tainted and witnesses, but do not require complete confidentiality. It's a balancing act. Of course, we want to make sure that you relay the company's anti-retaliation commitment to the employee, give them a copy of the policy if that will be helpful. Never agree to forego an investigation, even if the reporting party requests it. They may decide not to participate, but once we must move forward on behalf of the company and discuss what they want to seek out of the investigation. I think this is another tightrope to walk, because sometimes folks that feel very aggrieved say, I want the person fired, they want that extreme, or I don't want anything to happen, and I don't even want him or her to know that I made this complaint, neither of which is necessarily a reasonable conclusion to this. And there's a lot of things in between that may come of this investigation. So don't make commitments, but perhaps get a feel for what the reporting party may want to see how the investigation ends, and of course remain objective at all times. Now we're going to move on to interviewing the subject of the complaint. I'm not sure this is my second interview, but it could be. Again, we need to be flexible, and I think once you've talked to the reporting party, you may want to get some support before you talk to the accused. It's a judgment call for you. But again, we're going to remain objective. We're going to provide a full opportunity to explain a written statement, again, that may be supplemented. And I would always ask the complainant, I'm not done with my investigation. I have not even fully started it, and I will be back with you. But what information, documents do you believe exist that would support what you're telling me today? And I would urge you, when interviewing the accused as well, to ask them to be very specific about dates, times, words said, and don't be embarrassed by that. Interviewing witnesses can be challenging. You'll often get, no, next slide, please. You'll often get folks that just don't want to be involved and will try their best to give you the most limited information possible, so they don't get involved. But that's why I think some are good and some folks are good at this. You just you coax and you urge and you try to make that employee comfortable. Review their personnel file before, prior to the interview, and any other documents. Back to that confidentiality issue, I want you to be careful there. Another tightrope to watch. Privacy issues for the reporting party and the subject of the complaint. It's hard to. It's often difficult to interview someone about for example, a harassment complaint without using names. But if you don't use names, you may not get information. So you've got to be, cautious about what kind of information. But you may have to use the names of the people involved to see if there's anything going on between them. Have you seen any unusual activity? Have you seen anything that would make you uncomfortable about their interactions? But you are going to have to use those names. So, and I think most investigators understand we're going to provide the details of the complaint only if necessary. Whatever a certain level of information needs to be provided, but we need to be careful that we protect as much as we can. Just some thoughts on interviewing here. Open-ended and broad questions, of course, not leading. Chronological. Some people say, where to start? Well, let's just start at the beginning. I started working for your company on this date, and everything was smooth for about a year, and then this happened. Let's just take it chronologically. It's usually the most efficient way to conduct that investigation. As I said before, don't be afraid to ask tough or embarrassing questions. tell the individual you're talking to, I'm okay with it. I hope you're okay with it as well. Be okay with silence. You know, let's just let the person think and decide what they're going to reveal to you. We're looking for contradictions, evaluating body language, considering motives. Does an individual witness have a friendship or a hatred towards this supervisor or something like that? Remember, you're doing this interview because the company trusts you to do it. They trust your judgment, they trust your skills. So, you know, be okay with using them. A couple other thoughts here on interviewing witnesses. Ask witnesses about other witnesses. Right? Documentation is everything, but consider that everything is going to be discoverable. So what you write on your scratch pad and what you type up later are both potentially discoverable. So always have a closing statement. Anything else I should know? Any documents? Anybody else I should speak to? It's always a good way to end that interview. Let's pause for a moment here on this he said, she said issue. This is hard. A lot of people give up. It's too easy to give up here. Just right. I've got a he said, she said situation, and I'm concluding my investigation. I can't determine, and I would urge you to push further. The EOC actually has recommendations on determining witness credibility. You know, is plausible? Is the witness version of the facts believable? Does it make sense to the average person? Does the witness seem to be telling the truth? How is their demeanor? Do they have a reason to lie? Is there things that support one witness's version of the events and their past records? So those are some of the factors that the EEOC says use, but I continue to urge you to use your judgment. You are a professional, and your judgment is important in determining witness credibility. And if you need help on it, run it by someone else, but you're there to try to determine whether you can get past that he said, she said. In step 6, I'd circle back with the main players. It's time to come back. I've not reached a decision. The company's not reached a decision, but here's some follow-up questions I have from all my witness interviews and document review. So let's, when I say the main players, I'm talking for sure the accuser, for sure the accused, and perhaps other witnesses that may have some significant information. Part 7, step 7 is to reach a conclusion. Prepare a report, make recommendation of decisions on corrective action. You know, obviously some bullet points here for what you might want to consider and include. But as the last bullet tells you, sometimes the answer is we cannot conclude an infraction or a violation occurred as a conclusion. Just don't leave it hanging. We've either concluded that it occurred, it didn't occur, or we can't conclude, and why we can't conclude. Avoid legal conclusions. Avoid legal conclusions. Just be factual and try to weigh the evidence as impartially as you can. And then, of course, I don't know who have you made has decided to be the decision maker, whether it's you, the investigator, or someone else. But let's on the next slide note, let's consider what corrective action. There are a lot of possibilities. As I mentioned before, we've got folks that tend to take one extreme or the other, right? I want the death penalty, or I want nothing to happen to this individual. And there are a lot of options in between. No discipline, written discipline, some additional training, demotion, suspension, changes in compensation, or forfeiture of bonuses. Sometimes sends a strong message in conjunction with other written discipline. Risk management considerations. And this might be the time to get legal assistance. If you haven't been doing this investigation under the cloak of legal direction, this is probably the time for legal to step in. You know, those risk management considerations. What have we done? What's our past practice? What are the risk factors, protected categories of the parties? Are there operational considerations that we need to be mindful of in making a decision about moving someone, transferring, or terminating someone? Probably a good time here. Your report needs to be comprehensive. So include issues that could not have been resolved, include what the actions we took, and of course the person or persons making the final decision. Again, presume this report is going to be discovered. Step 8, last but almost not least, communicate the action taken, both to the reporting party and the subject of the complaint. People are very hesitant to go back to employees and say, we've taken discipline against John because of your complaint. But it is important that we tell the reporting party that something has happened that is meant to be corrective. So whether you're specific about the discipline, I don't think you need to be, but it does need to conclude with, we are quite certain that this will stop the behavior or prevent it from happening in the future. And if it doesn't, here's what we want you to do about it. And of course, we discuss anti-retaliation, limited confidentiality, and open door policies. Come forward if something further happens. Before I let you go, let's talk a little bit about attorney-client privilege. Obviously, it's a communication between a lawyer and a client, made in confidence for the purpose of seeking, obtaining, or providing legal advice. It matters because privileged communications are not required to be just involuntarily disclosed in court, subpoena, discovery, and depositions to the EEOC. However, there are times when you want a workplace investigation to be a non-privileged investigation. You'll see on the next slide, you've got a couple of types of, 4 types of communications that may trigger the privilege. Company requests legal advice. They're gathering information so it can provide legal advice. Attorney requesting the information or the actual provision of legal advice. Investigations requested at the request of counsel or conducted by counsel are generally privileged. You can't apply the privilege retroactively, and you must keep it confidential or it could be deemed to be waived. And the privilege is fragile. There's many times courts may apply it doesn't apply. They find that it doesn't apply. But I have found that it is often helpful to either waive the privilege or conduct a non-privileged investigation because you want to demonstrate the steps that were taken. I think it's important that you just realize that and decide it up front. Make the decision up front what you want this to look like. And my key takeaways are investigations are a critical part of your effort to provide a good workplace, diverse, inclusive workplace, free of harassment, discrimination, employees have a respectful place to work. Supervisor knowledge is company knowledge equals a duty to act. So even if it's acquired informally or outside of work. So it's really important when you train your managers and supervisors that you remind them of their obligation, that they are acting on behalf of the company at all times. When they receive a complaint or hear of a complaint, they have a duty to act and run, not walk, for help to human resources or legal. So confidentiality within your ranks, only release on a need-to-know basis, act quickly, move briskly on an investigation, and ensure your impartiality. And then proper documentation. I'm hoping that, as I said, my dense PowerPoint will provide some help and guidance for you as you undertake these or train your folks to do investigations within your organization. But it is, as I said, it's an art. It's an art.
It is indeed. Thank you, Andrea. That's terrific information. And your PowerPoint, I didn't find it dense. I found it as a cool path to how to do this. So thank you for taking the time to create that and share that with folks. And ladies and gentlemen, if you haven't been to the FisherPhillips.com website, there is a wealth of resources there for you in the labor and employment space. I strongly encourage you to devote some time to that. Andrea, quickly, I think in other presentations I've seen from you, you have shared with the audiences that retaliation claims tend to have higher levels of damages. I think I'm saying that right. Is that still the case? Are we still seeing?
We are
seeing those
claims are the largest number of claims filed of all the claims, because you compare them. I mean, think about this: a good plaintiff's attorney can say, "Listen, I may not be able to prove that my client was sexually harassed because we've got he said, she said, and some private conversations that we can't prove, but I sure will prove that my client was retaliated against after he or she made the complaint, because objective things happened, right? She didn't get a promotion, he didn't get a raise, he got transferred to the department, and you've got, so retaliation claims still continue to be on the rise year after year.
And often, I think it's fair to say, those claims, I think you just said this, are easier sometimes to prove than the underlying action, which gets us, yeah, no, it's, yeah. Listen, ladies and gentlemen, as Andrea pointed out, there's that natural instinct to retaliate, but that is why you need to invest in some emotional intelligence training for your folks. Andrea, I have one other quick question, and that is, we often hear, or we have a policy that says the complainant must put it in writing. Or we'll say they refused to put it in writing, so we didn't investigate. What's your feeling? Yeah, I kind of felt that was a rhetorical question for you for sure, but for everybody online, share with us your thoughts around that, will you please? Because I think that gets a lot of folks in trouble.
I think it does too. We certainly would want to encourage people to put in writing. You know, they take it a little bit more seriously. We tend to take it a little bit more seriously, but we would be making a grave mistake if we just didn't accept someone's verbal complaint. You memorialize it. If they come and say, "Are you willing to put this in writing?" and they say no, they say, "Well, sit across from me right now. Let's write it out. I'll write it out." Okay. So that I know what you're telling me.
Very good guidance. And then finally, there are businesses out there like Ethics Suite, who you're familiar with, that have these they're a third party that offers these dialing, anonymous ways to make complaints outside the company. What is your feeling about that? Or a third party ombuds person? Obviously given a scale that can support something like that. What is your feeling about those?
I think it's a great idea, and it can be done at very little cost or low cost. I mean, we want to make sure employees have multiple avenues to complain, and it's an important defense in most harassment cases. For example, under current Supreme Court law, if you had an opportunity to complain and you didn't take it, then that's a very strong defense for an employer. But even outside the idea of defending yourself, if an employee wants to bring a serious concern forward to you, they may only feel comfortable doing it when they don't have to sit face to face with a supervisor or human resources. Now, you get a lot of 1-800 I hate my supervisor calls. Mixed in with those, there's some gems of some complaints that you needed to know about, and I think it's fine.
And to your point of the cost of litigation, anything you can do to preempt some of that, I have to think, is a good idea. Yeah,
and it's the right thing to do.
Yeah, that also very good point. Ladies and gentlemen, Andrea and her team, the reason we come back to them time and time again is because not just of their knowledge about labor and employment challenges, but specifically about their knowledge of labor and employment challenges in the hospitality space. So again, check out their website, reach out to Andrea. They have a national practice. And Andrea, I was right. I think I read you guys had started to move into Mexico, right? You're opening up a little bit in the international space.
Mexico first.
Yeah, so those of you that are operating or thinking about operating there, keep Fisher Phillips in mind. Yes. Andrea, as always, thank you very much. Okay, let's say thank you to Lauren and Emily and Andrea, Gray Robinson, Foster Garvey, Fisher Phillips. That was terrific information, ladies. Thank you very much. Folks, we'll see you in the first quarter of 2024. We hope everybody has a safe holiday, and thank you for joining us today. Bye for now.